Yeah.
Say ready, action.
Ready, action.
So, as is implied in our nation's motto, E pluribus unum, ad many one, the Constitution of the United States arose from many contrasting viewpoints between the Federalists and Anti-Federalists. The major differences between the two reside in views upon national versus state government and the representation of each. These differences are illustrated within the Federalist and Anti-Federalist papers. In turn, the philosophies of these documents are evident in the Constitution. These Federalist and Anti-Federalist philosophies are also still relevant today through issues such as same-sex marriage rights. The differences between the Federalists and Anti-Federalists has had a large impact on the founding of our nation.
Federalist Paper number 85 by Alexander Hamilton states, "A nation without a national government is an awful spectacle." Hamilton's belief that a strong national government was necessary characterizes the Federalist argument. However, Anti-Federalist ideas about the federal government strongly contrasted those of the Federalists, as seen in Patrick Henry's statement that the Constitution is not an instrument for the government to restrain the people, it is an instrument for the people to restrain the government.
The uniting belief of different anti-federalist groups was that the people were not sovereign. The people were sovereign, not the government. This idea can further be seen in Anti-Federalist Essay 3 by John DeWitt. The people choose to direct their affairs under a government of their own choosing. The values of Federalists and Anti-Federalists on classical republicanism, natural rights, and powers of the states are embodied within the Constitution, as there are provisions for both empowering and limiting federal government in an effort to protect individual rights and the common good. Both agreed on the importance of natural rights. However, Anti-Federalists felt that they were not properly protected within the Constitution. As stated in Brutus No. 2, on this subject there is almost an entire silence.
The result of the Anti-Federalist disagreement led to the creation of the Bill of Rights. Another Anti-Federalist victory in the Constitution is seen in Article 4, Section 1, the Full Faith and Credit Clause. A contract signed in any one state has to be honored in all states, which retain state rights by validating their contracts and documents. The Federalists fought for a bicameral legislature in their Virginia plan, while the Anti-Federalists wanted a single-chamber legislature in their New Jersey plan. These two plans were combined to create the system we have today. It can be seen in Article 1, Sections 2 and 3, which established the Senate and House of Representatives.
Some of the debate about federal versus state power was resolved with the decision of McCulloch versus Maryland. The Supreme Court's decision to invoke the necessary and proper clause upheld the establishment of the U.S. Bank. This decision set the precedent that Congress has implied powers, aside from those that are explicitly stated within the Constitution, as long as these powers result in actions that benefit the nation, which embodies the idea of classical republicanism. The disagreement over the balance of power was one of the many factors that eventually led to the secession of the Southern states.
The Civil War was the greatest conflict over states' rights, and President Lincoln followed the Federalists' idea of national unity when he stated, "A house divided against itself cannot stand." Though the Civil War was resolved with the nation reuniting, the debate over states' power did not entirely end. It is still applicable to modern issues.
As David Osborne stated in his famous work, Laboratories of Democracy, today at both state and local levels we are in the midst of a new progressive era. The state and local experimentation of the 1980s may foreshadow a new national agenda. Today, the national agenda includes issues such as same-sex marriage that relate back to the Federalist and Anti-Federalist arguments.
The state and federal power struggle over same-sex marriage can be seen when, in 2010, the U.S. District Court for the state of Massachusetts found provisions within the Federal Defense of Marriage Act, DOMA, to be unconstitutional. DOMA is a federal law that defines marriage as the legal union of one man and one woman. In the recent election, Maine, Maryland, and Washington residents voted to allow same-sex marriage. The aforementioned Full Faith and Credit Clause mandates that same-sex marriage contracts have to be honored in states where it is not legal. The Full Faith and Credit Clause asserts state power over federal law and reflects anti-federalist values of states having more power.
Out of the crucible of debate between the Federalists and Anti-Federalists emerged important additions to the Constitution and questions that plague our society today. These debates are essential for preserving democracy today, as stated by Logan Pearsall Smith in Afterthoughts. For souls in growth, great quarrels are great emancipations. Thank you.
355.
Last 50 years, do you think we've become more Federalist or Anti-Federalist? Provide some specific examples. Last 50 years.
Well, in the recent election, I think we embodied more anti-federalist ideals when Colorado and Washington voted to legalize recreational marijuana, even though that's federally illegal.
The Affordable Care Act was a very federalist idea in that it kind of nationalized healthcare and it gave people a kind of national choice for healthcare, and it required everyone to have healthcare, and that was a very federalist idea in the last 50 years.
In your testimony, you mentioned some implied congressional power. What are some of those implied congressional powers that you were referring to?
Can't be this.
We don't know.
Do you think the Articles of Confederation were the perfect anti-federalist theory?
I don't think they were the perfect anti-federalist theory, because if they were, they would have been more successful. And obviously they weren't, because they had to amend it and create the Constitution.
I would disagree. Anti-Federalists wanted independent states, and Article 2 of the Articles of Confederation states that each state is independent and sovereign. So it was really just, the Articles were really just furthering the idea of independent states that the Anti-Federalists fought for.
I would have to agree with him. The Articles of Confederation also gave no power to the national government, in that they could not tax the states, which were sovereign. This strengthened their belief in that a centralized power should not be very strong, and that the states should have more power.
Agreeing with Lila, the Anti-Federalists themselves were not necessarily a unified group. They weren't their own core party like the Federalists were. The Anti-Federalists were really just a name for those who opposed the Federalists. So, no, the Articles of Confederation did not perfectly embody Anti-Federalist ideals, because those ideals were all very different from each other.
Throughout our nation's history, what do you think has been the greatest Federalist, anti-Federalist debate, and provide historical examples?
Well, the succession of the southern states and the right for states to succeed has been a crisis, an issue that was ongoing since the Constitution to the Civil War, starting with the nullification crisis, and then with Lincoln's victory and the Union's victory, that was ended.
And then, leading off the Civil War, civil rights has become a definite prominent anti-federalist and federalist debate. Following the Civil War, Reconstruction, many southern states asserted their rights of separate but equal under Plessy versus Ferguson, and it was not in conjunction with, it was in conjunction with federalism, sorry.
And this debate continued after Plessy versus Ferguson was overturned by Brown versus Board of Education, and Eisenhower furthered federal power by sending troops into Little Rock to enforce the Brown decision.
Going up and down the row, if you were alive after the Constitution convention had wrapped up, which side would you argue on? The Federalist side or the anti-Federalist side?
I would argue on the Federalist side, just based upon the weakness of the Articles of Confederation as demonstrated in Shays' Rebellion, and the non-unification of a military, but also the fact that the cause of the rebellion was the debt that the Articles of Confederation caused, and debt was just an overarching problem that the Articles could not resolve.
I also would have been on the side of the Federalists because, as Austin mentioned, those issues that they saw post Revolution era with the Articles of Confederation, and I would have been on the side of the Federalists so that something could be done about those issues.
If I were alive after the Constitution was drafted, I would have exactly no idea what they said because of the secrecy rule, and because I'm a woman, I would still have no idea, even though John Adams, his wife, wrote to remember the ladies. That wasn't exactly included within the Constitution, so I would have no idea.
I would have to side with the Federalists economically because they needed to have kind of raise taxes and impose taxes on the states and not have the states nullify these taxes in order to kind of strengthen the economy nationally. Socially, I would side with the Anti-Federalists in that the states should have the right to nullify certain laws that they may deem kind of hurtful to their social like construction in their state, for example,
Like how long is it?
slavery and I
That's
don't
good
know.
to know.
Why did so many writers of the Anti-Federalist and Federalist papers use pen names and not their actual names?
The writers didn't want to use their real names, and they used pen names because they didn't want people to associate the views within the Federalist and Anti-Federalist papers with their actual names. Many people, these men, such as John Jay and Alexander Hamilton and James Madison, were prominent men within the colonies, and many people already had opinions about them, and they didn't want their opinions about them to be in relation with the papers.
Additionally, they didn't want their reputations to suffer necessarily if their ideas were like resulted in public backlash. For the same reason that they had the secrecy rule at the Philadelphia Convention, I think is why they used pen names.
They also didn't want to create situations of name calling where you said this, he said this. They wanted to keep it civil and that they could just talk about the ideas rather than the people who wrote them.
Also, the use of Brutus and Publius are important names in democracy's history, and they really elevated their what they have to say.
Stop there.
I gave it too easy, one more question.